Well, first things first, Happy New Year and welcome back to Season 2 of Inside Medical Malpractice. We took a short break last month to rest and recoup and come up with some new ideas and topics for 2021. And we've got some great guests lined up. So thank you so much for joining us again. And I promise you that today's podcast won't disappoint. I just want to explain that due to some COVID-19 considerations, this is the first podcast that we're recording outside of the When Sparks Fly studio. So please forgive any little bumps in the road or noticeable changes to sound or video. We'll do our very best. But first of all, I'm really excited to introduce a very experienced malpractice lawyer, Brian Devlin. He's a plaintiff's lawyer from Law 51 law firm in Calgary, Alberta. I've known Brian for almost 20 years. He's one of the very first lawyers I ever worked for as a legal nurse consultant. I was nervous going into his office, I got to tell you, because this guy's got a reputation for not only being really experienced, but a little bit tough. Look at him right now. I don't know if you can see him, but he's got a reputation for being a solid lawyer and someone that you really don't want to mess with. And starting out, I knew very little about law and I knew very little about lawyers. I'd been an obstetrical nurse for 30 years. And Brian did something amazing the first time I met with him. I was nervous going in, and I think I actually said to him, I don't really know anything about the law. And he said to me, you don't need to know anything about the law. I know the law, and what I want you to know is nursing. And that sentence calmed me down then and has calmed me down 1,000 times since then, because I know nursing. I mean, at that point in my career, I knew things very well. After that first meeting in 2001 or 2002, Brian and I have kept in touch, both professionally and socially at different occasions. He's got some amazing stories to tell. And as he is now starting to wind down his career, some amazing insights to share with all of us. Before we start talking to Brian, let me talk to you a little bit about what an amazing lawyer he is. Brian started his career back in 1977 with the firm of Jones Black, which is now known as Bennett Jones. He originally articled under Jack Major QC, who later became a Supreme Court of Canada Justice. He received the Queen's Counsel or QC designation in 2002. He's published a book on medical malpractice. He's made the Best Lawyers in Canada list every year since 2010. Those are just a few of his accomplishments. He then practiced law in the firm of O'Brien, Devlin, McLeod for almost 43 years, and more recently has joined the firm of Law 51 to assist in the development and completion of their medical malpractice cases. He's got considerable experience and some great stories in criminal defense work. And for the past 26 years, he's represented seriously injured people in motor vehicle accidents, medical malpractice cases, and other types of serious personal injuries. Brian's appeared at all levels of court in Alberta and in the Supreme Court of Canada. He's conducted approximately 25 full medical malpractice trials in his career, some of which were litigated to the Alberta Court of Appeal. He's won and settled many cases involving a broad range of issues, including birth trauma, surgical error, laser eye surgery cases, delayed diagnosis of glaucoma, spinal cord injury, ER cases, delayed diagnosis of cancer, medication errors, and multiple complications from plastic surgery. I could tell you a lot more about this guy, but I think that gives you an idea of who he is and what he's done. So let's just start talking. Welcome, Brian.
Well, thanks very much, Chris. Good to see you.
It's good to see you too, and it's great to have you on this podcast. Thanks so much for being here. I just want to, first of all, thank you for taking the time to talk to us today. You and I have been talking about doing this podcast for several months, and there's been 1 or 20 things in the way for one reason or another, not the least of which is the COVID-19 pandemic, but here we are. So let's talk, first of all, a little bit about what led you into law originally, and your journey through the different types of practice that you've worked in, because I've heard stories from you about all kinds of stuff, and then how you finally landed in medical malpractice.
Sure. Well, it's probably a little bit unusual because, I came from a small town in Ontario. My dad worked in a cleaners, so I didn't know any lawyers. The only lawyer I ever bumped into when I was a kid was a lawyer who sort of helped me along when I got in a little trouble when I was a teenager. So that was the only experience I had with lawyers. So the idea of me becoming a lawyer was so foreign to me. I mean, it just wasn't something I even thought of. So anyway, I ended up going to university, mainly because there was, they had good loans, good student loans in those days. So I went to university and started taking an English degree. And while I was there, I played guitar with a guy, Ron Bilfeld. Anyway, we played guitar. I took up the guitar when I was in university, a little bit before that. But before that, I was in a band in high school, but I was the singer. I was the lead singer. So I took up the guitar and we started playing guitar in all these cafes and things around the university. Anyway, and towards the end of I guess it was second or halfway through third year, I said, so now what are we going to do? We're getting these English degrees. What can you do with that? And he said, well, I'm applying to law school. And I said, what? You'll never get into law school. Are you crazy? And he said, no, I think I can get in. And I said, well, if you're going to apply, I might as well apply too. So we both applied. There were three of us, actually. We all applied and we all got into Windsor Law School. But up to that point, really, it wasn't like I was dying to be a lawyer or that my dad was a lawyer or I had friends who were sons of lawyers or anything like that. It was just more happenstance than anything. I mean, I was always kind of interested in it. I got a lot more interested in it once we got to law school. But that was basically how I ended up going to law school. And back in those days, the LSAT thing was, I had pretty good marks in my English stuff. But the LSAT was not such a big deal as it is now. Like now they have courses you take and, a lot of it is dependent on the LSAT. But back at that time, I remember I read some little booklet about the LSAT and I went over to Kitchener and wrote the LSAT. Like it was like an IQ test, it wasn't something you really studied for. So I went over there and wrote the LSAT and I got, I did pretty well, which is probably why I got in. Anyway, so I wrote the LSAT and then I got into University of Windsor and off we went. And so that, that's basically how I ended up getting into law school. And then when I came out of law school, I met my previous partner, Noel O'Brien, who has been, practiced with me for over 40 years. I met him in law school and there were a bunch of guys who came out to Alberta. And at that time, 1976, Alberta was really booming. And so they were actually looking for lawyers to come out, believe it or not. So I had a call from Mac Jones at Bennett Jones, who was the head partner. He was the Jones in Bennett Jones Black. And he called me up and said, we've been sort of looking at, law students with good marks and so on. And would you be interested in coming out to Calgary? And I had a job lined up in Guelph and another one in Toronto. And I sort of said, well, where's Cal? I didn't even know where Calgary was. I think the only thing I'd ever heard of was the Calgary Stampede with all the horses running around. And so he said, no, Calgary's great. And you could come out here and show me. He said, I'll pay you. I'll pay your way to come down to Toronto and I'll put you up at the Royal York and you can meet me for breakfast. And then we'll see where we go from there. So he sent me a plane ticket, which was unheard of. Anyway, so I cashed in the plane ticket and I drove my old Studebaker down to Toronto and got a room in the Royal York. I'd never even been in the Royal York, but I thought that was pretty cool. Even if he didn't give me a job, at least, I got to stay in the Royal York. So anyway, I met him that morning. He's a great guy, and he always has been a great guy. He passed away just a little while ago now. But anyway, so we had a nice conversation. He showed me a picture of his house. He had this big house, pulled out of his wallet and said, you could have a big house like this someday. Look at how well I've done, blah, blah. And Calgary's wonderful. And he told me all about Calgary. And that sounded pretty good, here was a guy who wanted me as opposed to all these guys in Toronto who you were sort of begging to give you a crumb, And the other thing was in Alberta at the time, you didn't have to go through the long bar admission course like you did in Ontario. So in Ontario at that time, you were looking at about another year, basically of the bar admission course in addition to articling. So coming out to Alberta basically shortened the time for you to get admitted by about a year. So anyway, so I thought that sounded pretty good. So So Bennett Jones is good to me. I mean, they got me an apartment out here, and I drove out in a U-Haul and started working for them. And so that was great. So I articled with Jack, and Jack's probably one of the best lawyers I've ever met in my life, and a great guy, a wonderful guy, really, very down to earth, who later, of course, became a Supreme Court of Canada judge. And I learned a lot from him, but my first sort of introduction to medical malpractice was with him, because he was the doctor's defense guy, basically, in Alberta. I mean, he was the big gun. And he was in a few books as described as the doctor's man in Alberta and so on. So he was doing these cases, and he let me do some. Back in those days, they let articling students do a lot more than they do now. So he let me do some discoveries, or what they call questioning now, of doctors and defending doctors in the discoveries and so on. So anyway, I got a sort of an introduction there, but that never really went anywhere at that time, because I decided I wanted to be a criminal lawyer with Noel. And Noel and I were both going to be and did become criminal lawyers. So the day that we finished articles, we went out to dinner and we went out on our own, which is also kind of unheard of these days. So we just said, oh, well, let's go out on our own and we'll start doing criminal law and we'll do a bunch of legal aid. And so off we went. So I think I got admitted to the bar sometime around June 15th, 77. And I remember we started our firm the day of the Stampede Parade, because I remember we got all dressed up in our suits and everything. And we had the office, and we went down there to start. Our practice was going to start that day on a Friday, And we went down there, and the place was all locked up because of the parade. Closed up. So that was the big start to the whole thing. And anyway, then we got got the office going, and we basically did legal aid for the first couple of years. I remember we used to do what they called duty counsel, which was you got $140 to go down to the jail, the remand center, and the police station, and you'd see these guys who'd been arrested the night before. And then you'd go into court, and some of them would plead guilty. Some of them would put over to get a lawyer. And so, that's how we kind of survived for the first few months. And then we got going. We got going pretty well in criminal stuff. And both of us were doing, murder cases and like serious criminal stuff within a couple of years. And so I basically was a criminal lawyer from that point until probably, about the mid 80s, but in around 78, I got my first malpractice case that came into my office to me. And it was a guy named James Layden who had lost his leg because he was misdiagnosed. They said he had gout. This is up in a small town north of Calgary. But anyway, he was diagnosed with gout, and it turned out to be cellulitis, which caused infection, which he ended up because of the delay, ended up losing his leg. Well, that was the first case I had. I was about a year and a half or 2 years at the bar when I took that on, because he phoned me and said, do you know anybody, he just out of the blue, he said, do you know anybody who does medical malpractice, and could you refer me to somebody? And I really didn't know anybody that did it other than maybe Al Hunter, who was a Code Hunter, who was a prominent lawyer then. And so I said, you know what? I've read quite a bit about this in law school, and why don't I do it? I'll do it, So James and I, off we went, and we went all the way to trial. We won, was in front of Justice Robotham, and then it went to the Court of Appeal, and it was upheld, and it wasn't much money, but we won. So that was kind of a good introduction, let's say, to medical malpractice. I mean, I enjoyed doing criminal law. I did a lot of it. But once I got started doing the medical malpractice stuff, it seemed like, I don't know, it was more of a rewarding for me anyway. I mean, the criminal stuff, to be perfectly honest about it, I did all kinds of criminal stuff, you name it, drugs, rape, sex assault, murder. And the odd time you'd get a client who was actually innocent. Very rare, very rare to get a guy who actually didn't do anything. I can count them on my two hands, Anyway, so really, it seemed to me like a lot of it was playing the game. So you're playing a game, and the whole idea is to win. and get your guy off, and hell with the morality of it. I mean, you didn't worry about whether the guy was guilty or innocent. If he got off, that was great because you beat the system and you won. But, as far as reward, other than financially, the rewards of that, there's some satisfaction to that, but it's not the same as, succeeding in a case for, say, an injured baby or an injured person where you're giving them something that's actually going to help them, get on with their life and so on. So much more, I found it myself, much more satisfying. Anyway, some criminal guys would probably disagree with me. But I had, quite a few serious criminal cases. I did a case I was right around 79 too, for the guy they called the Southwest Rapist, who had allegedly raped something like, I think it was 15 women. He was charged with breaking in their houses and wearing a balaclava and raping them and doing all these terrible things. And so we had a big long trial for this guy. It was 2 months, which was unheard of in those days, like having a 2-month long trial, because we did the whole thing in a voir dire, and then we did a voir dire is like, doing a trial within the trial. So I won't get into all the details of that, but anyway, it ended up going. He was convicted. I think he got 7 years or something the first time, or whatever. No, it was less than that, 5 years. And then we went to the Supreme Court, which was all over similar fact evidence, because they had put in all these other cases trying to prove that he had committed one of them. And so without getting into all the legal details of it, I went to Supreme Court of Canada. That was, I think, in about, early 80s anyway. So I was, pretty fresh at the bar, probably 3 or 4 years at the bar. And Noel and I both had a case in the Supreme Court of Canada the same day with 2 full 9-person courts. So it's all been downhill from there, And we both won. So he went back and got a new trial and was finally resolved. Anyway, so the criminal stuff was, I was doing a lot of criminal, murders and you name it. And then slowly I started getting more of these malpractice sort of cases coming in. And it was probably, probably the early 80s to mid 80s where I started doing a lot of it. And then I was still doing criminal stuff because, basically as a malpractice lawyer, you need some financial backing to do some of these cases. And we didn't really have any financial backing. So the only financial backing was doing the criminal work, the criminal defense, which was a fairly quick turnover compared to the civil litigation. And so, we would use those funds to put towards these cases. And the other thing was, at that time, these medical malpractice cases didn't take, no cases took as long as they do now, but certainly medical cases, you'd get to trial in like 2 or 3 years max. Now it's not uncommon, 5, 6 and longer with injured children. It's often very long time. So it was a little easier to get things turned over, So anyway, I started doing more malpractice in the mid 80s. And I did the ones I remember. There's been so many. I've probably had malpractice in just about every medical situation you can think of now. But the early ones I remember were, there was a guy who was he had a disc problem in his back, and they had this at the time. They had this technology they developed was to inject what's called chymopapane into the disc. And the idea was that it was going to shrink. It would shrink the disc, and therefore they wouldn't have to do surgery, And that was written up, and it was used for quite a while. But what happened was the chymopapane was also toxic, and so with this particular man that I acted for, they put the injection in, and it went outside of the disc, and it went into the vertebra, into the spinal canal, which caused paralysis from the waist down. So, so there was him and another woman who had a back surgery, problem with back surgery. Those are the two I remember that up until about 80. I think I finished that last one with the lady who was also paralyzed from the waist down in about 87. And then I got my first big malpractice case, which was a guy, a native guy named Rod Pelletier, who was arrested on the Eden Valley Reserve. And in the course of his arrest, by the RCMP, his neck was broken, and he was a quadriplegic. And then they had put him in a jail cell. Like, they didn't realize, I guess, or they purported that they didn't know that he was paralyzed. They just thought he was drunk, and they put him in a jail cell. And then a doctor came in and saw him, but left him there for a while in the jail cell. Anyway, so that was my sort of first big case. And the thing is, you have to realize about talking about these things is that a lot of these cases have been settled, resolved, right? And you can't talk, like, they're all done with a confidentiality provision. So you're not allowed to talk about whether it was settled, how much was paid, etc. So a lot of these cases, I can only talk about the facts of them, not necessarily what happened. But anyway, Rod Pelletier was my first big case, and he was actually what they call a tetraplegic, because he was not only quadriplegic, but he had a breathing tube as well. So he couldn't breathe on his own. Anyway, so that case, I think I finished that case in about 93. And then from that point forward, medical malpractice became, a large percentage of my practice, probably like 80%. And then gradually the criminal stuff dropped off. And I think the last criminal jury trial I did was probably 15 years ago or so. So since, over that time, I gradually just did malpractice. And I also did, personal injury and motor vehicle accidents and stuff too. That was the other thing that paid the bills for the malpractice cases, because the malpractice cases are all or nothing. You go to court, you either win and get 100% or you lose and get nothing. And there's very few cases where there's any split off of liability or, percentage like there is in these motor vehicle cases. Like, it's very, very common for motor vehicle cases to say, well, this guy was 50% responsible and the other guy's 50% responsible, so you will pay 50% of the damages. But that's very rare in medical malpractice cases, because it's usually all or nothing. And so, you needed to build up some financial backing before you could really get into these serious cases. So, since that time, I've done so many of them. Injured children cases, and there was a time when you probably remember when LASIK surgery first came on, and LASIK surgery was the new magic way to fix your vision. You notice I still have glasses, and I did a lot of those because there was a big bump of these laser surgeries. Everybody was getting laser surgery, and so there were all these problems with the laser. There were initially there were problems called different things called the Sands of Sahara, where you'd have this thing and then you couldn't drive at night and you'd have blurry vision, and there were a lot of cases that were quite serious too. I remember having a case where the lady, she developed what they call ectasia. So when they do these laser surgeries, they take off a bit of your cornea, and if they take too much, you can develop what's called ectasia, which is basically an imbalance in the eye, so that your cornea doesn't have enough thickness to maintain its stability. And if that happens, you can't be corrected with glasses or contact lenses. And so the only sort of cure for that is a corneal transplant. So I had a couple cases of that, but I did a lot of laser surgery cases because there seemed to be a lot of them that had problems especially in the early days. I haven't seen one now for quite a while, because I think the lasers now are so much better, and there's not as much sort of human input, if you will. Like, they put in the formula, the machine does it. So I haven't seen very many of them, but for a while there, I had a doctor named Craig Beattie, who was my expert out of Vancouver. And he was really good on those laser cases, and we did a lot of them together over the years. And the other area, aside from infants who have suffered brain damage through lack of oxygen during birth, I've done quite a few of those cases too. But the other big area that I remember was doing gallbladder cases, because the thing that had happened was they developed, it's sort of the same time as laser surgery, they developed laparoscopic surgery, where now instead of opening a person up, you're doing it with a scope, where you're putting these metal scopes in, and it's, if it works, it's great. because you don't have the big scar, you're back to work faster. And they were doing this with many things, including gallbladders. And, most people would think, well, gallbladder is no big deal. They take them out all the time. It's routine. And it usually is. But when they go bad, they can go really bad, as you probably know as a nurse. And so, I had a few of those where the results were very serious, where there's, without getting into details of it, your gallbladder has what's called a cystic duct, which attaches to your common bile duct. And one of the biggest problems in doing these surgeries is the identification of the anatomy, right? So you have to make sure that when you clip off and cut the cystic duct to take out the gallbladder, that you've identified the cystic duct rather than the common bile duct. Because the common bile duct, if you injure that, that's a life-threatening situation, because now the bile from your liver is not going to drain properly. You get really sick really fast. I had many of those cases. Most of them recovered pretty well. They had a lot of problems, but they recovered. But the one I remember having is a lady who had suffered an injury like that, and then there was a delay in sort of diagnosing it. And unfortunately for her, as a result of laying in the hospital for 4 or 5 days, she became septic, and she suffered, brain damage. She suffered organ damage, and it was a terrible case. So those cases, although routine, can turn into something very very nasty. And we had a lot of those too, a lot of other laparoscopic things too. So you sort of look at what developed in medicine and how the malpractice cases developed from the technology, and you sort of see that relationship. And then hopefully things get better as they develop better routines and better checks and balances and so on. Anyway, so I've been rambling on, but that's how I sort of got into all this.
Well, first of all, that was a great answer, so thank you. And just your knowledge and your experience comes shining through and all that. A couple of comments from me, just as going back a little bit to what you talked about in the beginning. I had just a little vision once I got into medical legal work that I would try writing the LSAT. It was probably 15 years ago. I sucked. I couldn't even touch it. It was so difficult. I thought, I'm smart. My IQ is relatively high. I'm good. And I couldn't even touch it. So it's interesting to, I'm actually, sorry.
That's why I say it's almost more like an aptitude, or at least at the time, it was more like an aptitude or an IQ sort of test. If you had a certain way of thinking, you would do really well. Yeah. And if you didn't think that way, you would do terrible. Yeah. And, the idea was, well, if you don't think like a lawyer should think, even at that stage, you're probably, you may be wasting your time going into law school and doing something that you're going to find extremely difficult. Yeah. But anyway,
interesting.
At the time I did it, it didn't seem, I didn't think it was very hard. I mean, it was, it took 3 or 4 hours. Yeah. But it was basically I remember the only questions I had trouble with were the ones where they'd say, okay, yeah, 5 people are standing at a train station and 3 of them get on the train and 2 of them take a car and then 2 more get off in 60 miles and, all that stuff. Right. Oh, I found those were pretty tough. But the rest of it wasn't too bad.
Yeah, and you're just looking for the box that says, I don't have a clue what that question, I don't have any idea. But anyway, congratulations. And it's so interesting to hear. You're not the first lawyer I've talked to that kind of fell into law a little bit, that didn't necessarily have a law family or didn't have a plan. They just thought they'd give it a try. And interestingly enough, working as a nurse a few times, you'd hear the medical students sitting at the desk and at the nurse's station, and they'd be just chatting about how they got into medicine. And that story isn't that unfamiliar with doctors as well. They just say, well, I just thought I'd try it and I passed the test, so here I am. But I think, that's true for a lot of us that we just fall into. But I was just struck once again. We've talked a lot of times about a lot of different cases, and I'm always, I love it because your medical knowledge is so in depth. And You've taught me a few things about medicine in the past. I remember you teaching me about the peroneal nerve. And in my experience as a labor and delivery nurse, all I knew about was the perineum and the perineal area. And I thought you've taught me some stuff. So how challenging has that been as you moved into malpractice to learn the medicine that you have to learn for every case? Challenging and rewarding. I guess that's a double-edged question because you know a lot.
It was very challenging at the beginning. I mean, I've been doing this for 40 years now, so I can look at medical records and I sort of know what I'm looking at. But when I first started, my wife, used to be a crime reporter when I met her, that's how I met her. But anyway, she would go up, I'd send her up to the law library or the library, medical library, and she would research some of these things, some of these issues. And they had a librarian up there who was very helpful. And she would pull out the right textbooks, and you could learn about spinal cords and cauda equina syndrome and all these various things. But really, I mean, I didn't know anything about medicine at all. And now it's much easier. And now, of course, we have the internet, which is the greatest thing ever, because I can go on there and find out about what the issue I'm looking at in 10 minutes, really. Like I can find the anatomy, I can go on Wikipedia, I can go on these surgical sites. I can even see surgeries being performed. I mean, I've gone on there and watched these guys doing an actual gallbladder surgery or But back then in the 70s and early 80s, there was none of that. There was none of that. So the only way to do it was to go to a library and try and figure this out so you could at least understand what they were talking about. And then the other problem, of course, was finding an expert. There's the guys who are going to educate you and answer the questions, as to whether you have a case. That was the biggest, I mean, that's always been a problem, but that was the biggest problem back then, was there were very, very few doctors who were willing to step up and even give an opinion. I mean, I'll tell you I'll tell you what happened. The first case I did, I mentioned that James Layden case. So I phoned around a couple doctors I knew from doing motor vehicle accidents, and asked them, well, do you know any orthopedic surgeon or a surgeon who could talk to me about this problem with the cellulitis in the leg? And they referred me to a guy, I won't name him, but he was a well-known orthopedic guy, a surgeon in town. And he was very receptive, He said, send me the records. Yeah, I'll help you out. No problem. I'll have a look at it. And then he called me up to his office. And I'll never forget this. I went in there and I'm sitting there. I'm like 28 or something. And he says, well, Brian, this is a very interesting situation, and I feel so sorry for your man, and what he's suffered. But I just don't think there's any blame to be put on anyone here. I mean, yes, he lost his leg, and yes, he was misdiagnosed, but, it's an error of judgment, and anyone could have made this error of judgment. And I think you should tell him that it's not in his interest to carry on with this, So I went out of there and thinking, oh my God, this is not good. But I was convinced that there was something wrong here. I mean, a guy goes into hospital with a little cut in his foot and he ends up losing his leg. It's just a gut feeling that. So I've called Al Hunter, who was a very good guy and very receptive for young lawyers to talk to him. And he was the only guy that I knew really, other than Jack, who was doing any malpractice cases at the time. This would be back in like 78, 79. And he was with a firm called Code Hunter. And he was doing a case with Jack where he was suing a psychiatrist. And that was the case that Jack sent me over to sit in on the questioning. So I sort of knew this guy. Anyway, I phoned him up and he said, yeah, I could probably find you somebody. And he referred me to two guys. One was Dr. Atkinson and the other, Grisdale was the other one. Anyway, and they were both, they knew Al. So because they knew Al Hunter, they were sort of receptive to me because I was referred. Whereas if you went in there cold, they'd probably say, well, here's this young lawyer, get rid of him. But anyway, so they ended up giving me opinions, which were very supportive, and they testified at the trial and their evidence was accepted. But it was very, that's what I had to go through just to find somebody. And then have somebody tell you, you don't have a case. This is, it's very interesting, but forget it, son,
So tell me, Brian, what did you say to that doctor when he said that?
Well, I tried to argue with him, and I tried to point out the things that I thought were negligent and so on. But he just kind of blew me off. And so I didn't say much. I mean, there's no point. What's the point arguing with the guy? He's not going to help you. And you paid him up some money, and now you're out of money and you don't have an opinion to help you. So but I just felt like there's something wrong here. And I've had that feeling on cases since then too. So sometimes you have to go the extra mile. And even though you get an opinion that's not helpful, you don't necessarily have to accept that. There are differences. I mean, every case almost, there's a difference of opinion between the plaintiff's experts and the defense. So, you just have to decide whether it's worth persevering or not. And sometimes it isn't. Sometimes you get an opinion and it makes sense. And, I mean, I'm not a medical doctor, so I rely on these guys to tell me that, the facts of life. But I mean, just because you're not a doctor doesn't mean you can't go and read a textbook about how this is done and what the features are. And now, of course, there's been a lot more litigation, so there are other cases too which have been decided. But back then that was a big problem, getting experts. And it's still not, I mean, you can get experts now, but they cost a fortune. And we can get into that later about the costs of these.
Yeah.
What has happened. Because doing a malpractice case now is very expensive and very long and very time consuming. And that's why a lot of people are not being compensated for their injuries.
Yeah, well, we're definitely going to get into that because I know you have some comments about how we could be doing better, some of the issues and problems. Two things. One is, I'm in the business of expert witness work and finding experts. And it's kind of interesting because it's not like you can just say, here's what we'll give you, we're going to pay X amount dollars an hour, and that's what you'll get for expert. Experts set their own rates basically. And, it is challenging, and I understand that, but we'll talk a bit more about that. But I wanted to go back, your connection of kind of an onslaught of new lawsuits with the introduction of new medical technology. I've never actually thought about that before. So when you're talking about all those laser cases that came around and then the laparoscopic gallbladder surgeries, tell me a little bit about how you feel your medical malpractice or your work in malpractice has perhaps changed healthcare or improved outcomes. What are your comments on that?
Sure. Well, it's not just, I wouldn't say anything to do with my particular cases, but I think overall, there's two sides to the coin, right? One side is, yes, you had a malpractice situation, and yes, you were negligent, and yes, this terrible injury happened, and so how can you prevent that? And there have been a lot of changes that I'm aware of in medical procedures and checks and balances that have tried to address some of those problems. Like, for example, I had a case where, believe it or not, the woman went in to have breast reduction, and they cut the wrong breast, right? So, I mean, you can believe these things that happen. Many of these weird things happen. They're very rare. But anyway, I had a guy who they took out his, I remember the doctor came to see him after he came out of the operation, and they said, well, the good news is we've removed your gallbladder. But we realized then that you weren't really here for your gallbladder, you were here for your hernia. So we fixed your hernia, and the good news is we've now taken out your gallbladder, so you don't have to worry about that either. So now they have, I've read that the doctors in surgery now use a similar technique to what they use in airlines and pilots when they have a checklist. They have a particular checklist of all the things, including which leg are we operating on, yes. And they even mark it, and they check with a patient. They ask the patient before they put him to sleep, tell me again, sir, what are we here for? What are we operating on? Is it your left leg? Is your right leg? And so they have a lot more checks and balances. And that's just a fairly straightforward example. But I'm sure there are many other things that I'm not really completely aware of. But I know that these malpractice cases definitely have an effect. And the CMPA, which is the Canadian Medical Protective Association, part of their mandate, in addition to defending doctors, is doing exactly what you're talking about. In other words, they try to educate doctors about these kinds of cases and things to avoid and safety for the patients. So, they do a lot of work in relation to that. And I'm sure a lot of it is driven by the fact that there are lawsuits in which they're paying out large amounts of money.
Yeah, no doubt. And I've actually never spoken to an expert that hasn't said just reviewing one case or 3 cases, medical malpractice case, hasn't really changed their practice. Because, working in healthcare, these things can happen, but unless you're involved in it, you don't really, I guess the thing that you don't really understand, especially in acute care medicine, is something bad will happen and that patient is discharged and you will never hear the outcome until or unless there's a lawsuit. And of course, as we all know, many of these medical errors don't end up in a lawsuit. So, and maybe 6 or 7 years later, there'll be a policy change and somehow related to the incident or 2 that happened earlier. So it's kind of a breakdown in communication in the acute care healthcare, that that these things are there and that they happen, but they're somewhere out there and they don't necessarily happen to you. And you don't fully understand the impact to the patient. And I think that's what working in as an expert witness has really taught me. You do not really understand. And I can remember you one time when I asked you about what's like the classic patient or client that walks into your office. And you said 2 things to me, which I've never forgotten. You described, you first of all said that there's never been anybody who walked into my office that wasn't just as mad as hell. They were just done and at the end of their rope by the time they came to see a lawyer. And you described your classic case as a laparoscopic gallbladder, the laparoscopic cholecystectomy, as being at that time what was just going on all the time. It was new technology. The signs of early infection and complications are soft. They get sent home after 24 hours. They're back in the ER after 48 hours. They're sent home because the signs are still a little on the soft side. They think maybe just an infection, and then they're back, in 72 hours in really big trouble. So it's kind of interesting what you're talking about, how the CMPA helps to educate doctors, because it's important work. I don't think we all know. Life is just busy and patient turnover is rapid, and you don't hear the end of the story.
Well, I think it does have positive effects in that way. The negative effects of it, which you often hear from politicians who are in charge of paying money for the healthcare system, is because of medical malpractice cases, there are so many tests done that aren't really necessary. Like you're sending a guy for an MRI because you're worried there's a rare chance he might have some problem that some lawyer is going to get after you for because you didn't do an MRI, or didn't do an X-ray, you didn't do a blood test or whatever. So that's the other side of the coin, is that the healthcare sort of profession or whatever complains about the fact that they are required to do these various tests. I mean, I'm sure you're aware of this. When really it's not, maybe not be necessary. But the problem is you don't know if it's necessary if you don't do the test, right? So they have to do them. It's just the way, it's just the way it should be. Whatever.
Yeah, that's often referred to as defensive medicine, and certainly it's a thing. I had an experience not too long ago in the United States having to see a doctor there, and I have a daughter who lives in New York, and she was out jogging a few months ago, and she was bit right in the butt by a dog, a Rottweiler, which freaked her out. This dog just grabbed onto her bottom and, hung on, ripped her leggings, her joggers that she was wearing. And there was a little break in the skin, and she didn't know what to do. She was at home alone. She had just moved to New York, and she called an ambulance because the owner of the dog he got very defensive, and he just kind of blew a gasket, and the scene got a little bit ugly. Someone called, actually, I don't think it was her, but someone called the paramedics. And of course she called me, and I got on the phone with these paramedics and I said, show me her bottom. And, there wasn't a break. There was a little bit of redness, but there was no blood. There was no real break in the skin. And one of the paramedics said to me, what I would recommend is that we transport her immediately to a level 3 trauma center emergency room to get this checked out. And in my mind, I mean, I just thought, wait a sec. I mean, first of all, here in the U.S., there in the U.S., that would be a $12,000 bill if she ended up there for any length of time. And so there was an older, there are two paramedics here, and there was an older lady that was also on this team. And I said, put her on for just a second. And I said, just look me square in the eye and tell me what we should do in this situation. And she said, she's just fine. Just tell her to keep an eye on things and to FaceTime you every day and show you her bottom so you can make sure there's no infection, which is exactly what we did. But that was the most extreme version of defensive medicine I have ever seen. And I understand it was in the US, and, as you will well know, litigation is different and damages are different and causation maybe is different, but it does happen.
Yeah, I would think it's more pronounced in the United States than here, simply because they have more, more litigation down there and more malpractice claims and so on. So it's developed over years, but it's it's an issue here as well. I mean, I'm aware of that. I mean, so I don't think it's a bad thing though necessarily. I mean, like something you're describing is pretty crazy because
it was crazy. It was crazy.
Yeah. But so people coming in with pain in their chest and what have you, and sometimes they're sent home, and you wonder, should they have had a test, and they don't have a test, and they have a heart attack at home, and so it's always better to do the test. I mean, I had a couple of years ago, I had a medical problem myself, and I had turned out to be a blood clot in my lung, right?
I remember that, Brian. I remember that.
I thought I just had a bad cold, or maybe my doctor, my GP thought maybe you got a touch of pneumonia or something. Anyway, I went into the hospital, and my friend who was in our band is an ER guy. He was there, and he saw me there, and he said, "What are you doing here?" And I said, "Well, I got this problem, He said, "Well, come on in here," and so he checked me out, and then he sent me for a CT scan, which he was kind of reluctant. He said, "Well, I'm not, this probably is nothing to worry about, but maybe we should send you for a CT." So he did, and they found this, and so I was on blood thinners for about 4 months or something. But I mean, the point is, if they hadn't done that, I could, it could have developed into something very serious. So, there's two sides of the coin, and it's left to the judgment of the doctors as to whether it's reasonable or not. You want to take your chances. You're taking a chance for you and the patient.
Yeah, that's a very good example of, therein lies the problem of the decision and knowing how much testing and how much not to do.
Mm-hmm.
So you are well-known and very well-respected and successsure and slightly feared in some circles malpractice lawyer. And I say that with all due respect. And I see you chuckling at that. I'm sure that brings you a little bit of joy, perhaps.
I don't think I'm feared very much anymore. I'm too old to be feared.
But I talk to lawyers and I talk to people, and your name comes up quite often as being a very well respected and highly experienced medical malpractice lawyer. What's our audience includes all kinds of ages and people, and doctors and lawyers, young and old, and nurses and the public. What's been your secret to success?
Well, that's a big question because, I've had a certain approach, which I've learned over the years to malpractice cases. And I think most lawyers who do this follow the same, more or less the same pattern. The thing with malpractice act is unlike any other sort of law because the client is trying to persuade you to take his case. Whereas in most other cases, you as a lawyer are trying to get him to hire you. But when people come in with malpractice cases, they're so risky and so difficult and expensive that, you have to be very careful about which ones you take. Because if you take one and you spend a lot of money on it and time and so on, you could go bankrupt in like 2 years. So the whole idea, at least in my practice, has been to try and do as much as possible upfront. So the person comes in, you get all the records, you get an expert, you fully investigate the case before you jump into filing a claim and proceeding. And the problem with some lawyers who are not experienced in this area, like some lawyers who are personal injury lawyers, for example, they think, well, here's a malpractice case, just like I did when I was 28. They say, well, I'll jump into this and, But if you don't do that work at the front end, then what happens is you file a statement of claim, you get going on the thing, you go through what's called questioning now, or examination of the doctor and so on, and you get way into this thing and you get way down the road, and then you try and find an expert because you don't have one, and the expert says, you know what, there's no case here. So then you have to go back to your client and say, well, I thought there was a great case here because I'm so smart, and I didn't need an expert to say there was a great case. Now we have to prove it in court, and we have a problem. And the other thing that a lot of people don't realize is that the CMPA does not settle cases easily. If you can't show that you have a good case and you have an expert to back you up, there's very limited chance that they're going to settle with you. And of course, if you don't have a good expert, you're going to lose a trial anyway. So, my sort of approach has always been to do the work up front. And that way, at least if you have a decent expert to back you up, then you have a chance. It doesn't mean you're going to win, but you have a chance of winning or settling. And if you don't have a good expert, there is no chance. Without an expert, you can't go to trial, really. There's the odd sort of situation where you might get away with it, but it would have to be so blatant that basically the law is, anyone would know it's negligence, that you wouldn't need a doctor to say it was negligent, like cutting off the wrong leg or something. But, generally speaking, that's kind of the approach, is to do the work at the beginning, do a really detailed, reading of the records and a chronological review. Well, you've seen the kind of reviews we do, and use somebody like yourself even to go through the records and so on. And to do that before you launch into this thing and get somebody spending a bunch of money like these people are angry, they're stressed out. All they want to do is blame somebody. And if you encourage that without the evidence to back you up, you're not doing them any good, because 3 years down the road, they're going to be on the hook for costs possibly, and be very disappointed in the whole enterprise. So that's the first thing. The other big thing that I've always had a big problem with is what I call the white knight syndrome. And I wrote about this in that little book that we did. But the problem is, here you are, you're a lawyer, you're sitting in your office, and this person comes in and they tell you this terrible, terrible story, and it practically brings tears to your eyes. Maybe it does, about their child or about them or whatever, or their mother who died in horrible circumstances. And the inclination is to say, I'm going to help. I'll help you. I'll do this, because you don't want to send them out of the office. You don't want to disappoint them. And then a lot of people get really angry if you tell them, look, I don't think there's a case here. And they'll say, well, what do you mean? Where am I supposed to get a lawyer? And I can't, but you have to, and it took me a long time to sort of develop this, but you have to develop a technique of isolating the ones that are just not going anywhere, and being able to deal with people and tell them the truth, tell them the facts of life. Don't, encourage them on to something that's going to be disappointing in the end. So those two things, if you can show that you've got an expert, you've got a good cause of action, and it's worth some money. That's the other thing. There's no sense taking I've gone all the way to trial on cases that were, I think the lowest one I ever did was about $30,000 or $40,000. So you're talking about 3 years of work going through a whole trial, and the award is like $30,000, and the fee for the lawyer is like $5,000 or $6,000. You can't make a living doing that. But on the other hand, if you take on these smaller cases, and you don't, if they're good, and you don't take them all the way through, then the defense is going to say, well, that Devlin guy, he's not going to go to trial in this case. It's only worth X amount of money. We'll just delay this forever and he'll go away. And if you look at the stats, from the CMPA website, you can go to their website, and they have, they're fairly reasonably transparent, because they'll say how many cases they have in a year, how many they settled, how many they were, abandoned. And you find that probably approximately 50% of them are abandoned, where people just walk away, or lawyers walk away from them.
Well, there you go. I mean, that's probably part of your developing your tough guy. I mean, you're persistent, going to win this case, take it to the end reputation. It's interesting that you brought that up. I think so. If I heard you right, for you to say to do all your upfront homework and put down your white knight syndrome, it's all about vetting case and finding the cases that are money. It's all about vetting the cases. Is that right? Taking on cases.
It's all about case choice at the beginning.
Yeah, right.
Taking on the cases that you think you have a reasonable chance of settling or winning.
Got it.
And the thing is, when I first started doing this, the main issue was standard of care or negligence. So if you could win on negligence, there was very little discussion about causation. Like in that example I gave you of that James Layden case where he lost his leg, I don't remember there being any argument about causation at all. It was just if you proved negligence, you were pretty much home free. And that continued for a while. But then the defense really started to develop the causation arguments on these cases. And now causation is probably a bigger issue than standard of care. And especially in, compromised infant cases, they've spent a lot. They have a lot of experts. They've spent a lot of money in developing defenses to those kind of cases, which are usually cerebral palsy type of, the cause of cerebral palsy, and was it caused by anything that happened during the delivery and so on. But that becomes, in a lot of cases, the main issue now.
So is that, in your view, been a good thing or a bad thing that the focus has moved from standard of care to causation?
Well, from a plaintiff's point of view, it's a bad thing because now you have to fight a lot more about causation, and you have to deal with a lot of these very sophisticated experts and literature, and obviously, but it's in reality, it's probably a fair thing that if you were negligent but you didn't actually cause the injury, then you shouldn't be responsible. That's the bottom line. Yeah. So, there's nothing wrong with it as a matter of law, but things have, like medical malpractice law, I can just talk about that for a second without getting too detailed. The standard of care part of it, which is in layman's terms, the negligence part of it, has not really changed much. The law and standard of care is more or less the same. The standard of a reasonably competent doctor with the same credentials, basically. What would he have done? What would a reasonably competent doctor with those credentials have done? And if it's below that, he's negligent. If it's above that or within that, then he's not. But the causation law is always changing and changed a lot over my practice. In 40 years, it's changed amazingly. We went through stages where you could get away with proving a material contribution rather than, I don't get into too much detail about this, but the basic law now is that if you can prove that the injury would not have happened but for the negligence, that's proving causation. But there was a time when there was a case called Affey and Leonati, which developed a whole theory that if you could show material contribution to the injury, that was enough. And anyway, there was this whole sort of mound of cases that went through that whole thing. And then it now has resolved back to the basic but-for test. And the material contribution test is rarely applied now because it only applies in very rare circumstances. And that went, that issue went to the Supreme Court of Canada, I think 3 or 4 times, and it's changed over the last 40 years or so, up and down, all over the place. So that stuff, that law changes. The standard of care law doesn't really change very much. And so the causation law and the medicine changes all the time. Like obviously the medicine, when they were doing open surgeries or they didn't have this particular type of equipment, that type of thing changes all the time. But the basic law of negligence doesn't really change that much.
Yeah, it is what it is. So you've seen a lot of changes in malpractice law. Let's move a little bit to talking about what's working and what problems in your view still exist, and then perhaps what you'd like to see changed.
Well, let me just tell you a little bit about how things sort of developed over the time I've been practicing. Like when I first started practicing, the limitation in Alberta for suing a doctor was 1 year. 1 year, and there was no what they call discoverability. So the usual example given is, I've done a surgery on you. I left the scissors in your abdomen. Year and a half later, you developed a stomach ache and went to get an x-ray, and by God, there was a pair of scissors in your abdomen. And back at that time, there was no discoverability rule. So once you're past the 1 year, that was it. So even though you found the scissors later on, didn't matter, right? So I remember when I first started practicing, everybody, we all were complaining about that. Oh, that's unfair. How could that possibly be fair that a person who doesn't even know they've been injured now can't sue when they find out they have been injured? And so gradually, over many years, they developed discoverability, which is now in our law, and they extended the limitation period to 2 years from the time you knew or ought to have known that you'd suffered an injury, which gives you, much more leeway. Because back in those days, 1 year is nothing. And if you have a serious medical issue and you come rolling out of the hospital and you're in bed at home for months, the chances that you're going to be able to go and hire a lawyer and investigate this, pretty rare. But there were things like if you're under a disability, like you were unconscious or something, maybe you'd extend the period. But other than that, there wasn't much extension. And there was a lot of literature and professors and lawyers arguing that it should be changed because it was unfair. And then judges started getting on board with it. And eventually discoverability was sort of brought in the Supreme Court of Canada. And then the legislation was changed. So now we have discoverability and we have a longer limitation period. And the other thing in Alberta, they, you have an exemption from the limitation period for children until they're 18. So before it was just the regular 2 year period, and it was all based on their parent, what the parent knew and so on. But now, children have until their age, like 2 years from when they turn 18 to actually file a claim, which is a huge difference. Anyway, so I had a case that I took it over, and it took, I think it was almost 18 years by the time it was done. And that whole limitation issue, like the changes, the whole question was, when did those changes come in and did they affect this person and could they rely on them and so on? So that has definitely changed for the better. The rest of it, I don't know how much that's really changed for the better. There are probably in my, and what I'm saying to you is just my experience, but other lawyers might disagree. But as far as getting experts, I think now it's easier, let's say, to get an expert. There are services like yours like your company, for example, that was never there before. There was a guy in Toronto that I used for years, still use him sometimes, who ran a similar service to what you do as far as finding experts. But for the most part, you had to seek out your experts on your own. So I'd go to, if I had a doctor that had testified for me in one case or give me a report, I'd go to him because I knew, number one, he was willing to do it. Number two, he sort of knew me now, so he sort of trusted me, and he would refer me to somebody else. Or I'd go read some cases where doctors had testified. Because, back in the early days, I think doctors are very reluctant. And I had one doctor, I'm trying to remember what that case was about, but I know he was a surgeon, and he actually came and testified in court. And then he told me he moved away from Calgary, and he told me later when I talked to him that he had been more or less ostracized by his fellows, and didn't feel comfortable after doing it. And, that I think that was much more common back in the 70s and 80s than it is now. I think more doctors have recognized their sort of obligation to the profession to give an honest opinion. But you still have to be careful, and you still have to find them. And they're expensive. That's the next thing. It's nothing now to pay, $10,000 for a report. Even I've paid as high as $35,000 for guys to actually come, give an opinion and then come to court on some of these injured baby type of situations. It can get very expensive. And so the problem is not the fact that it's expensive. The problem is that people really, there's no access to justice other than finding a lawyer who's willing to take your case and usually pay at least part of the expenses. I mean, if you're wealthy, you can afford to do these things, then it's okay, because you can find a good expert, you can pay them. It's like justice for the wealthy, same old story. If you got $1 million and your child's been seriously injured, you can go hire a good lawyer, you can get good experts, you can pay them, you can go all the way to court, and if you lose, well, you've lost some money, but you had lots of money anyway. But majority of people are not in that situation. And when they're injured, it's even worse, because now they're not working. Most of them are financially strapped. So unless they can find a lawyer who's willing to do it, who can do it, who's willing to do it, and who's going to, put up the money to do it, they're not going to get any help. And there's only so many lawyers around, and that are doing this work. And I know in Calgary, I can only think of 3 or 4 or 5 lawyers that do any of this kind of work. And it's more or less the same in Edmonton. And the reason basically is it's very high risk. It's all or nothing. It's very expensive. It's very time consuming. Trials take forever. And now with COVID, it's ridiculous. But before COVID, I have a trial set right now in October of 2022, which was set about 2 years before COVID came along. So even before COVID, there was a huge delay in the system. Now they've appointed a bunch more judges, and so hopefully it'll get better. But there was a big delay. And so the money, the expense, finding a lawyer and so on. So most people just don't have access to a lawyer. And if you've been injured, but your case is worth, say, $100,000 or $50,000, good luck finding a lawyer who's going to be willing to put in all the time and effort on that kind of case. Who knows what he's doing.
Do you have any suggestions for fixing that problem, the access to justice, basically?
Yeah,
I think what you said. Do you? What?
I have suggestions, but they have not gone over well with anybody, really. My feeling on the matter was that, like this, and I used to be very critical of the CMPA and the lawyers for the CMPA, and I used to say, well, they're so aggressive in their scorched earth policy and all this stuff. But I've kind of moved away from that, because I basically recognize myself that this is a system. Okay, we have a system, and if you have an adversarial system, which is what our system of justice is, adversarial, one lawyer against another lawyer. You put lawyers into that situation, they're going to do what lawyers do. They're going to try to win for their client every way legally possible. They're going to fight like hell, and it's going to take forever. It's going to cost a lot of money. And, that's the system. That's what's going to happen as long as you have that system. And so the problem with that system is just what I just said, that there's a big imbalance, because, and I'm not saying the doctors aren't entitled to defend themselves, they are, but they have, this organization, which is very well funded. They pay their, annual fees to it. If you look at their website, they have something like, $5.5 billion in the bank or something like that. And they're well organized. They have very good lawyers, and they are in the business of defending these guys, and reasonably so, and with the plaintiff's side of things, you have a few lawyers. Most of them are only, a lot of the really good sort of experienced guys are only willing to take on very big cases, like infant cases, for which the damages are millions of dollars. You talk about some of these lawyers in Toronto, for example, that I think you've had on your show or on your podcast. They're mainly put themselves forward as taking on compromised baby cases, for example, or very serious injury cases. And so that's fine. that's fine. There's probably enough lawyers that, the reward and at the end of the day and the issues in the case there's enough lawyers who will take some of those cases on. But your average sort of case, that's not to say that in your average case, people can find lawyers and they don't have the money to hire the experts, even if they do. So what's the answer? So, people have talked about a no-fault system where there would be people would be compensated sort of like they are with workers' compensation or something, where if you're injured in a hospital and you had a right to some compensation, you would get that without having to show fault on the part of the doctors and so on. But I mean, when you look at the system, that's almost impossible because all kinds of people end up with bad results coming out of hospitals. So you can't just compensate everybody. There's just not enough money to support the health system, let alone to pay for everybody who's injured in the health system. So my thinking was that the way to do it would be possibly to have some kind of a fund which was set up so that people could access that fund, or alternatively to have a committee of independent sort of doctors who would review these cases. And it's not really no fault. They would find that there's a reason that the person should be compensated based on, standard of care issues, but that the person would not have to hire a lawyer, pay all this money for experts, and put up with 5 or 6 years of delay to get to trial. And I don't know the details. There's different systems that have been tried down in the States where the other side of the coin is, if half of the cases are being abandoned, that probably tells you that a lot of them don't have a lot of merit. I mean, I'm not saying that all those cases have merit. You would think that if they're being abandoned, that somebody has decided that there's no point in proceeding further with it. And so some of the systems down in the States, and I can't remember which states, but they demand that the law is that you have to have an opinion from an expert before you can even file a case, which is, the other side is saying, well, we got all these frivolous cases. How do we eliminate the frivolous ones so we don't have to spend all the money on that? But the way it is, all this money is going from the doctors to the CMPA, which is fine. And the CMPA is defending them, and they'll defend them to the end of the earth if they think that they're not negligent, and they have the money to support it, and they have the experts. But your average person doesn't have access to it. So how do you resolve that problem? And it seems to me the only way to resolve it would be to have some kind of a fund or some kind of a committee of independent experts that could review cases and at least, try to give you some idea of whether you've got something. And a more expedited way of dealing with it by mediation, rather than having to go through what is really a sort of an antiquated adversarial system. I mean, our system is developed over centuries, and it's all based on, lawyer versus lawyer, fight it out in court. Now, I mean, getting to court is so expensive. Now, not only do you have to pay, maybe you're not aware of this, but now, in Alberta, for example, you have to pay to file a statement of claim. Then you have to pay to file a certificate of readiness to get a trial date. Then, that's not enough. Then you have to actually pay for the days you're in court. After 4 days, I think it's $250 a day. So when I set a case for a month, my client has to pay, or I have to pay, money just for the purpose of going to court.
Oh. I didn't know that. I wasn't aware of that.
I said a month-long trial is about $3,500, $4,000 on top of everything else you've had to pay, all the experts' fees, all the filing fees, the discovery transcripts, all this stuff. And this is the put in a couple of years ago that you have to pay. And now that's not enough. Now they have a levy. They just did this a week ago or so, where the Law Society says, well, we're going to have a levy on the civil litigation of $175 per claim. So now, in addition to all that, now you have to pay $175 more on top of the $250 to file the statement of claim. It's just like a constant outflow of money. And then we have the this system of expert reports and all this stuff, which tends to, everything tends to be delayed. And with COVID, of course, it's even worse. But it's not a great system. It's just that simple. So the answer is not to criticize the lawyers. Lawyers will do, it's like putting a lion in a jungle with an antelope. You know what I mean? They're going to do what they're going to do. That's what they do. They fight it out. They try to win, but as long as you continue with that system, you're going to have the same problems that we have, that the majority of people are not being.
Yeah. That's interesting. And I think that's a topic for a show all in itself, because, just statistically, I happen to know in healthcare, the number of preventable serious injuries versus the number of cases that ever make it through court or settlement that are compensated are about 1,000 miles apart, and not that I'm terribly litigious or want things to be terribly litigious, but I know 5 people in my own family that have had some relatively serious injuries that were due to medical error, and none of them were pursued as a lawsuit for 1,000 reasons, but one of them was that they weren't the multi-million-dollar cases. You've mentioned quite a few times about how expensive it is for the client, and I just want to clarify for the public listening: do most lawyers take medical malpractice cases on contingency? Or has your practice been, if you take a case on, that the client will pay for the expert reports in this court time that you're describing? How does that work for you anyway?
For me personally, the usual practice is that we take all these cases are on contingency. In other words, nobody pays any fees to the lawyer unless we win or settle the case. But on the expenses part of it, I try to get clients to pay the disbursements, or at least part of the disbursements, for a number of reasons. Number one, just the financial, it's very expensive to put up all that money. But also it's sort of, the client is more invested in the case. In other words, if you take the case and the client has no money into it and is not required to do anything, it's sometimes difficult to get instructions from people like that, because they expect the world, and there's no downside for them as far as putting money into it. So they may very well say, well, you may have a reasonable offer of settlement, but that's not good enough. Go to trial, and you may not think that's a good idea. But anyway, so and different lawyers have different practices. I mean, I certainly take some cases on where I pay all the disbursements. I've done several cases for children where the parents are strapped. And the first case I did, that Rod Pelletier case, I was like 20. How old was I then? In the 90s. Can't remember. I'm so old. I was probably 40. And I put out all the money on that. I had about over $100,000 of my own money out in that case. And these cases are high risk. And my wife kept saying to me, "How much more money are you putting into that? We're going to lose our house." So when you do that, especially when you're younger and you don't have a lot of financial backing, it's you lose one and it hurts, boy. It's going to set you back. But
I think many people don't consider that the actual running of a business of a lawyer and the need to stay,
Well, yeah, I mean, you got to pay the overhead and so on. And a lot of guys do pay. Like, for example, in motor vehicle cases, most lawyers, certainly in Calgary, pay the disbursements because they have to compete, because the people will go to the lawyers who will pay their disbursements. And most motor vehicle cases, the liability is not really usually a big issue. There are some where it's a big issue. But most times somebody runs into you when you're stopped at a stoplight, you're going to get paid, right? So if you put out the disbursements for the person, you're going to get the money back. It's like, investing money in the stock market or something. It's better. But that's not the case with malpractice. With malpractice, there's no guarantee you're going to win or settle. And it's a lot more money, usually, especially the bigger cases.
Definitely.
So,
yeah.
You can only I've always done this stuff basically on my own. I mean, I had my two partners, Don McLeod and Noel O'Brien, who were both criminal lawyers. and I was a criminal lawyer. And so they were great they're great trial lawyers, excellent trial lawyers, but they don't do this type of work. But they were, they're there to bounce things off of and talk about strategies and things like that. And we had a practice which was bringing in, fees for the criminal defense, which we could then apply to some of these cases. So, but basically, I mean, I all these cases, I basically did them totally on my own. I didn't have I had an articling student a couple of times, but I never had really juniors who sat in with me. Last trial I did against somebody from Bennett Jones, they had the main lawyer, a junior lawyer, and an articling student. They're like the whole front row was lawyers. And anyway, it's kind of nice to have somebody else with you, but that's just the way it worked out for me. And there's not a lot of malpractice lawyers that have large firms either. Most of them are, Weir Bowen and Joe Miller and those guys up in Edmonton, they have a number of lawyers doing this. But in Calgary, Cumming and Gillespie, maybe they have several lawyers. But other than that, anybody else that I know of is basically on their own doing it.
Yeah, I think you're right with that. There's very few who do just sole medical malpractice. There's they have a mixed practice. So you've mentioned the sparsity or the scarcity of talented and experienced medical malpractice lawyers a couple of times. How do you see this? And I know from working with lawyers across the country, there's not a lot of 28-year-old upstarts like you were at the beginning who have the, financial backing and maybe the nerve to go to the Supreme Court when you got 3 years under your belt. So how do you see this handover? I've heard people talk about the graying of the bar and a couple of other things, however you want to call it. How do you see this handover going from experienced guys like you to the up and coming men and women who are dipping their toes in malpractice law?
Well, I think the days of going out and hanging up your shingle the day after you finish articling are pretty much over for everybody. I mean, for anything. I mean, you might be able to swing it at doing legal aid criminal work or something, but it's pretty difficult now compared to what it was back in the 70s. But as far as getting experience, I mean, I basically, I sort of look at my career or whatever you want to call it, and all the studying and all the medical stuff I've gone through. And, I have a lot of knowledge about this stuff. And so when I was thinking about fully retiring, like back in right before COVID, our lease was up. And so I decided, well, maybe it's time to pack it in, go traveling or whatever. And but then COVID hit. And then I thought, well, I've got all this experience, like really, it's kind of a waste to just quit and not provide anything to anybody or be available. So that's why I joined Steve Breslauer and Derek Nash, who are both, Steve is relatively junior. Derek is probably been, 15 years at the bar. But Steve was very interested in developing a malpractice, practice. And so he was helping me in a few of my cases before over the last couple of years. And then I decided to join them just as counsel. So, what that means as counsel, I'm sort of a mentor or whatever. And I'm still practicing, but I'm not in there every day or anything. But, to pass on that sort of at least a bit of knowledge about how to do these things and what they're all about. And that's fine. But, I don't know. I mean, other than some of these firms that have more than one lawyer, I mean, unless you got a real big thing going, how do you, I don't think I could have done it if I just said, okay, I'm going to do medical malpractice starting day one. There's no way. There's no way. First of all, there wasn't enough of it, and it was too expensive and too long a turnover. So it was the criminal defense work and the motor vehicle. I did a lot of motor vehicle stuff too, which paid the bills. And then I could go on with this medical stuff and put in the money. But as far as educating, I don't know. It's pretty difficult. I mean, most of these junior lawyers who come out and want to do this end up going with a defense firm like Bennett Jones or Gowlings because, they have a number of lawyers doing this. They have experienced guys there who will teach them. And then presumably they would go from there maybe out to act for the plaintiffs, but I don't see too many of them going out acting for the plaintiffs. It's sort of like the defense, criminal defense guys. A lot of them start out as prosecutors. They get into court every day. They get experience, they get to know the judges, and then they go out and, start up their own practice. But I don't know the answer to that. It's not an easy thing. There's not that many guys that you can hook up with, or that can afford to hire you, for that matter. So,
does it make you worry at all about the future or the status of malpractice law?
Yeah. And I've talked to people about it who have also, done some of this work, and some of them have gone to the bench and so on. And the concern is that there may not be anybody that you can. It's bad enough trying to find a lawyer and trying to, find out if you've got a case and all this stuff. But if there's only 2 or 3 lawyers in the whole city who are willing to take these things on, it makes it even more difficult to ever get compensated. And so a lot of people, I think, walk away from it. And a lot of people, though, a lot of people came to me over the years because they were so angry about what happened to them. But you have all kinds of people who don't want to sue, even though something's happened, because they've known their doctor for years, for example, or they like the guy. They feel sorry for him because he made a mistake. Mistakes happen. People are human, blah, blah, blah. So they're very forgiving, a lot of people. But where these doctors have, they're their own worst enemy in some ways, in some cases, because if they're arrogant or they don't explain things to people, people get upset, and then they come and see somebody like me. That's just the way it is. Yeah.
Absolutely. Well, it'll be interesting to see how that plays out in the future. I mean, just even as in my own expert work, every once in a while I get called by a fairly inexperienced lawyer, and perhaps I've done a lot of obstetrical work, as you know, and a birth trauma case would land in their lap, and they'd call me and to talk about perhaps me being an expert. And it's unsettling, even from the expert point of view, to be working with a lawyer who you just think you don't feel like the family's in good hands, and you don't feel like they're well-versed in doing what they're doing.
Any junior lawyer who's taking on a birth trauma case with any experience, it's insane. They're the most difficult cases, the most expensive, and the most risk to everybody. To the plaintiff for losing the case, to the lawyer for being sued, for screwing it up. I mean, they shouldn't be doing it. The best advice you could give them is to talk to somebody who is experienced at the very minimum.
Yes. Well, I just want to say thanks for taking on the role of mentor at this point in your career. And I hope that many other lawyers do, because as an outsider in this, it's just obvious that there's going to be, 7, 8, 9, 10 top plaintiffs, malpractice lawyers stepping down in the next certainly 5 years, and certainly within 10 years, there's going to be a big turnover. And
all the guys that I know, and I've met quite a few lawyers who do this kind of work from Ontario, BC, and they're all getting up there like me. They're all in their 70s, so they're not going to be around forever.
No, of course not. No, of course not.
So
yeah, exactly.
Yeah.
So listen, Brian, I think we should maybe just think about wrapping up this part of the podcast. I want to come back in a few minutes and talk to you a little bit more about your personal life and self, which I'm as interested to hear about. But before we go, I want to just ask one specific question for 3 different audiences. Our podcast listeners include lawyers, healthcare providers, doctors and nurses, and the general public. And you've got a lot of years and experience behind you. What is the one thing? How many
years I have?
You mentioned you're in your 70s. You started in 1977, and that's not exactly yesterday. But I'm saying that with all respect and admiration. I started nursing in 1978, so I am not too far off where you are. And I'm not. I don't know how it happened, but I'm not. Yeah, and so... But I just am being very respectful of your knowledge and your experience. So in your view, here's the question that I'd like you to answer for 3 different audiences. What's the most important thing that you would like healthcare providers, doctors and nurses specifically, to know about medical malpractice?
Well, again, speaking strictly for myself, they should know that I don't launch these actions cavalierly. In other words, I know how difficult it is for one of these, especially these young doctors, to get sued. I mean, I can imagine it's just probably the worst stress they've had in their whole career. When you suddenly get through med school, you're on your way in your career, and then bang, something happens, and you've got a lawsuit hanging over your head, and it's going to be there for 5 or 6 years. So, speaking strictly for myself, I mean, I try to make sure that I've got a good reason to be suing somebody before I ever do it. So it's not done lightly, and it's not done without some, serious investigation beforehand. So, I'm not saying that all lawyers do that, and sometimes people come in at the last minute. The limitation is going to run out tomorrow, and you have to file, but that still gives you another year. But, they should know that, that at least I think all the senior guys doing this, they're not doing it on a whim. They're doing it based on what happened and based on understanding of the facts and the medicine and the expert opinions involved. So no one is doing it just to try and get a quick settlement. No one should be thinking that they're going to sue some doctor and it's like a rear-ender motor vehicle collision where you write one letter to the insurance company and send you a check for a couple $1 million. That does not happen ever. So, I would just want them to know that it's something we take lightly, and that it's there's some considerable effort that goes into it before that ever comes to pass.
Well, look at that. The tough guy has a soft heart.
Not really.
Not really. But I appreciate that you said that, because without a doubt, there's a perception in healthcare that medical malpractice exists to be a thorn in your side versus, to help patients be compensated for injuries. But thank you for saying that. And I think you probably do have a bit of a soft heart in there. How about answer that same question? What is the most important thing that you'd like other lawyers to know, and maybe the upstarts or people who are thinking about moving their practice into malpractice? What would you like them to know about a medical malpractice practice?
Well, I've probably already covered it, but it's not something to jump into lightly. It's something that you have to look, as a lawyer, you have to look at it in terms of, can I do this? Can I afford to do it? Can I really represent these people properly? And if not, if you come to the conclusion that you can't, then you shouldn't take the case, or you should at least maybe partner up with somebody who has some more experience or whatever. But getting into doing a malpractice case, it's not, if you've done a bunch of personal injury work, it's not that different. The damages part of it are not different at all. It's the liability and understanding the medicine and what you have to do, what experts are appropriate for the circumstances. And you can find that stuff out. It's not impossible by any means, but it's not going to be easy. And so if you're a guy who's got a good personal injury practice going, and you're used to settling with insurance companies, and you've never done a trial or one trial in your life, the chances of you taking on a big malpractice case, it's not a good idea without some further experience. And that's all I would say is be careful about it, and try to do, if you do it, do the work up front, do the investigation, get an expert, and don't ever launch a statement of claim and get your client involved in one of these things without knowing that you at least have a decent expert to back you up and a good chance of either settling or winning. Because if you do, you're in for a long road.
That sounds like some damn fine advice right there. How about answer that same question now for the public, the general public? What is the most important thing you'd like them to know about medical malpractice?
Well, I guess the most important thing is that just because something happened in the hospital or a doctor was involved and someone suffered an injury or a death does not mean that the medical profession or the hospital are responsible. It's not, I was injured while I was in the hospital, or I had a bad result, therefore they're at fault. They're only at fault if you can show that they were actually negligent and did something that was, and it has to be something pretty serious, a serious breach of duty before you get to the point where you have a legitimate claim. And the other thing is if it's not, substantial, like I have people call me all the time over, somebody goes in to see a dentist, for example, and they have a sore in their mouth for 2 weeks or something. Minor injuries and so on are just not worth what it's going to take. So if you talk to a lawyer, chances are they're going to tell you that, and it's not going to be, unless you should have a serious case and a serious reason to think somebody did something wrong. And if you do, that's fine, get a lawyer and look into it and they'll investigate it. But don't assume that just because you had a bad result from a medical person or in the hospital that it's their fault. And I see that all the time. Somebody will say, well, I went in there for this and my surgery didn't work out very well, or my knee replacement didn't work out. Well, medicine's not a strict black and white science. It's more of an art. And so these things can happen. These things can happen without anybody being at fault. People die every day and get injured in hospitals, and it's not necessarily anybody's fault. But if you think it is, then, you should have it investigated.
Another piece of good advice. That's really good and really solid. Yeah. Call a lawyer. Can they call you?
Well, most lawyers are doing this kind of stuff. Will talk to you on the phone without charging anything, or even have you come in the office. Like I never charge people for a phone interview or for the first time in the office. And of course we don't charge them anyway because it's on contingency. But like I said at the beginning, these are cases where the client is trying to persuade you to take the case. It's not me trying to persuade them I should have the case. I don't need it. And so they have to persuade me that they have a decent case. And that's the big difference. And so to persuade me that you got a good case, I have to do all this. First, I have to get by, do I think it's worth looking into at all? And then I have to get by do all the investigation and everything else. And they all should also be aware that it's not a guaranteed thing and that it takes a long time. And I tell most people when I talk to them about getting into these lawsuits, that look, this is a very stressful, you've just been through a very stressful problem and you've got injuries or whatever's going on. Getting involved in a lawsuit is extremely stressful and will be stressful for the next number of years. And so unless it's very serious and unless you or your child needs, serious compensation to take care of them, think carefully about getting into it before you jump into it.
That's good. I appreciate too that you said that you can call, and that first consultation with most lawyers will be free, because I think a lot of people, that in itself is a barrier. They just think if you get on the phone and call a lawyer, it's going to cost a lot of money just from the first conversation. So thanks for saying that. Yeah. So before we wrap this up, is there anything else you'd like to tell us?
About what?
It's your choice, Brian.
I guess all I can say is that I after moving from criminal law, I always found criminal law was a lot more fun than medical malpractice. Criminal law was fun. You meet great people, I acted for a motorcycle gang. I met all kinds of crazy people doing criminal law, and it was great. I didn't mind it. It was fun. Malpractice is a lot more serious, and the consequences of criminal are serious too, but the consequences it's a lot more stress on you as a lawyer, because now say you're acting for a child, and if you don't win, this child's going to have nothing for the rest of his life, and even if you don't get, the highest possible award you can get, if you get enough to take care of that child, and you've done that through investigation, and your work, then it feels pretty good. It feels pretty good. It's not like having some guy who murdered somebody and he walks out of court because the witness got cross-examined and screwed up. And so to me, the criminal law was it was more fun. It was more of a game, but the reward at the end of it was not nearly as satisfying as achieving some success for these people.
See, I told you there's a heart in there. I just saw it.
Small.
Small.
Shriveled.
Small and shriveled. Is that what you said?
Piece of coal, sort of.
Oh. Well, anyway, I think we'll wrap this part of the interview up. And I just want to say thanks, Brian. That's an absolute pleasure. I mean, we've had a lot of...
for inviting me. I appreciate it.
Yeah, you're welcome. We've had a lot of good talks about a lot of different things. And I've learned a lot by talking to you today. So thanks so much. If you haven't heard it yet, don't miss listening to the shorter podcast titled Learn More About Brian Devlin to get a closer look at Brian the person and what makes him tick. Don't miss it. Thank you once again for tuning into Inside Medical Malpractice. As I explained at the beginning of the podcast, we're doing this for the first time outside of the studio because of some COVID considerations. And I personally heard a few blips and emails come in and doors close and things like that. So please forgive the technical difficulties that we had today. It is what it is. And we're doing our best with what we have right now. So once again, Brian, thank you. And we'll sign off on this podcast for now and be back with another one.
Great. Thanks very much.